new UGC anti-discrimination rules, it has created a lot of ruckus right now. What exactly happened? Let me break it down very simply to you. Recently, UGC, University Grants Commission, notified the Promotion of Equity in Higher Education Institution Regulations 2026. These rules were introduced after the Supreme Court, while hearing the cases of suicide of Rohit Vemula and Payal Tadvi, observed that UGC's 2012 anti-discrimination guidelines were not being implemented properly and it lacked fast-track accountability. So to address this, UGC framed new regulations under the UGC Act with the aim of preventing discrimination in colleges and universities based on caste, religion, gender, race, place of birth, disability, and other social identities. First of all, regulations expanded the legal meaning of discrimination. Discrimination was defined to include direct, indirect, or implied conduct, even if it is unintentional, if it impaired equal access to education or violated human dignity, on the grounds such as caste, religion, gender, race, place of birth, disability, and other social identities. The emphasis was on impact and not only intent. The second, the responsibility shifted to the institutions itself. University was no longer facilitators, they became accountable enforcement bodies legally required to prevent, identify, and respond to discrimination. Third, the regulations mandated equity committees, monitoring teams, and helplines with representations from SC, ST, OBC, women, person with disabilities. Representation of women and persons with disability was not caste restricted. Fourth, the time-bound procedure was introduced, emergency meetings to be held within 24 hours of the complaint, preliminary examinations within the 7 days, report to be furnished within 14 days. These timelines were meant for the fact-finding and review, not automatic punishment. Fifth, actions under the regulations were institutional and disciplinary, not criminal by fault. Only serious cases could be escalated beyond the university. Finally, the institutions had to file annual compliance reports with the UGC, creating regulatory oversight. These provisions aimed to create fast-track accountability, but concerns over the procedural safeguards and misuse led to judicial review. After the notification, the student-led protests emerged outside the UGC headquarters in Delhi. Concerns were raised from different groups regarding committee composition, lack of explicit safeguards for the accused, absence of provisions dealing with the false and malicious complaints. So various petitions were filed before the Supreme Court. The Supreme Court has now stayed the operation of 2026 regulations, observed that in their current form they could divide the society, directed the government and the UGC to redraft the rules, removing the bias and ensuring the balance, clarified that UGC regulations 2012 will continue to apply, fixed the next hearing date on 19th March. That's where the matter stands today. This is not the end. The final shape of the campus anti-discrimination law will depend on what the court decides the next. What do you think? Giving this authority of forming these rules to the UGC is the right decision or not? And also if the SC/ST Act in itself is sufficient for this? Or do we really need these regulations? Do let me know in the comment section.